good morning, good afternoon, and good evening, depending on your location and time zone. My people, Obajugodoro, a lot of people have said something concerning this issue of Mazi Nnamdi Kanu disgracing all his lawyers. I repeat, all his lawyers, both the one that are SAN and the one that are not SAN. The reason is what I'm about to tell you. Number one of the reason is this: if you cannot get me victory, then get me conviction. Mazi Nnamdi Kanu cried out on top of his voice and said, can you get me conviction? At least let them convict me to prison. Let me know that I am serving prison in Kuje, or get me victory. But these ones, none of the SANS, at least one SAN that came the other last time, Michael Zekome, is able to deliver Mazi Nnamdi Kanu to quash all the whole charges of terrorism and treasonable felony when appeal court granted him a discharge and acquitted. But this ones now is just only names and what I call it, and big grammar is what we keep hearing every now and then, every court appearance. Thank God Aloy Ejimakor is not there yesterday. He would have come outside again to speak big grammar. So I don't say Mazi Nnamdi Kanu don't shout to Eba na de homma, make ona free me, or maybe Kukuma send me to Kuje prison. If you people cannot get these victories, then let me defend myself. If I die, in fact, all die be die. Mazi Nnamdi Kanu opportunity which bring borrow. Anyway, let us update you on Kanu Agabi's withdrawal from representing Mazi Nnamdi Kanu. This is not withdrawal. This is disgrace. You may call it sack, but no, he disgraced them because all of them walk out of the courtroom with their heads bent down. Anyway, let us read the article before we say any other thing. So that when I don't go talk, say me, I talk too much because I have a lot of angry bird on this my channel. Any small thing they don't start to get angry. More than all they get angry. Oh, achoro obi umane. Ejikwe ketsindo wa. Oh, agatakwara me ya. Anyway, my people, oya, let us go there. Like, share, comment, and make sure you keep subscribing for more interesting videos. Yesterday being October 23, 2025, during proceedings at the Federal High Court Abuja, presided over by Injustice James Omotosho, lead counsel Kanu Agabi SAN, a former Attorney General of the Federation, formally applied to withdraw his representation to Mazi Nnamdi Kanu, the detained leader of the Indigenous People of Biafra, IPOB. This move was confirmed by Kanu himself in open court, where he announced his decision to represent himself moving forward. All other senior advocates of Nigeria, which is SANS, on the defense team previously including figures like Onyekachi Ikpeazu SAN, Emeka Etiaba SAN, and Paul Erokoro SAN, also withdraw from the case. Moving forward, reason for withdrawal: Agabi informed the court that Kanu had taken the case back from the legal team, indicating a deliberate choice by the defendant to proceed that is self-representation in all the whole matters. This aligns with the notice Kanu personally filed on October 21, 2025, signaling his intent to enter his defense and requesting a 90-day adjournment to prepare witnesses. Kanu's response: Kanu confirmed the withdrawal and stated, I will be representing myself for now. That might change later. He declined the judge's offer to assign a court-appointed lawyer, emphasizing his preference for independence at the stage. Representing himself orally, Kanu challenged the court jurisdiction over his trial, arguing it lacks authority to hear the terrorism charges against him. He has listed high-profile witnesses, including former Attorney General of the Federation, Abubakar Malami, FCT Minister Nyesom Wike, Minister of Works Dave Umahi, Lagos Governor Babajide Sanwo-Olu, Retired General Tukur Brutai, Retired General Theophilus Danjuma, and others to support his defense. The development follows the prosecution closure of its case earlier in 2025 and the rejection of a no case submission by the defense in July of 2025 as well. It also comes hours after Free Mazi Nnamdi Kanu protest in Abuja led by activist Omoyele Sowore demanding Kanu's release. Sowore later met Kanu in court and described him as powerful and unrelenting. Kanu has been detained by the Department of State Service DSS since his extraordinary rendition from Kenya in June of 2021. He faces a 7-count amended charge of terrorism, incitement, and affiliation with a prescribed group under the Terrorism Prevention Act. The trial resumed in March 2025 after multiple appeals and venue changes. Agabi joined as a lead counsel in March 2025, bringing a team of prominent SANS to replace earlier lawyers like Ifeanyi Ejiofor and Mike Uzekome, SAN, who had withdrawn previously under Agabi's leadership. The defense filed a no-case submission in June of 2025, arguing the prosecution failed to establish prima facie evidence, though this was overruled, paving the way for Kanu's defense phase. This is not the first reported tension. In May of 2025, Agabi was briefly denied access to Kanu by the DSS, prompting complainants of interference with fair trial rights. With Kanu now self-representing the court, may adjourn briefly to allow preparation, but this could introduce delays or procedural challenges. Observers note it as a bold but risky move, given the complexity of terrorism charges. Supporters view this as Kanu asserting control amid perceived injustices, while critics suggest it reflects disinterest in the trial process. IPOB has maintained global campaigns for his unconditional release, framing the case as politically motivated. Moving forward, court gives Kanu 24 hours to defend terrorism charges against him, or he will be sentenced to prison in Kuje. The Federal High Court in Abuja has ordered the Biafra Nation agitator Nnamdi Kanu to open his defense on October 24, which is today, in the terrorism charges brought against him by the Fulani government of Nigeria. Justice James Omotosho ruled that the defense must be opened without fail on Friday, October 24, or Kanu will be deemed to have waived the opportunity provided to him by the law. The judge's decision followed Kanu's insistence on defending himself in the trial, while requesting 3-month adjournment. At this point, the judge reminded him that an accelerated trial schedule had already been set and still subsisted, meaning a long adjournment could not be granted. Kanu, however, continued to challenge the jurisdictions of the court to proceed with the trial. The judge reminded him that the issue of jurisdiction had already been resolved against him. Justice James Omotosho pleaded with Kanu to see reasons and allow proceedings to move forward, but the defendant insisted that they should not. Kanu stated, "Going forward, I am making an oral application challenging the jurisdictions of the court to try him. On the face of the records before this court, there are 4 jurisdictions defects in the matter. The federal government is in contempt of the Court of Appeal. I have been discharged by the court, but I remained in detention for 14 more months. A contemnor cannot come to the court to seek any remedy because he who goes to equity must appear with clean hands. The act on which I am being tried has been repealed, and therefore I could not be tried on a repealed act. The prosecution has denied me proper consultation with my lawyers for the almost 5 good years I have been held in custody. If not for your mercy, my Lord, to grant us 3 hours to hold conference in this courtroom, I would have been compelled to enter my defense in a capital offense without proper consultation with my lawyers. The medical report on which this court relied to declare me fit to stand trial was forged. The report was dated 23 September, even though the court gave the order on 26 September. Kanu further argued that no blood or urine samples have been taken from him to conduct any test, rendering the medical report fabricated. Based on these claims, he asked the court to terminate the matter immediately, if possible. Responding, counsel to the federal government Adeboyoga Awomolo, SAN, said that the Kanu's statements were not based on any recognized court procedure and amounted merely to entertaining the court. In his ruling, Justice Omotosho said all preliminary objections could not be entertained at this stage, and the court order stood. The defendant must put in his defense. The judge noted that most of the Kanu's arguments have been raised before, but he is not foreclosed from the addressing them again in his final written submission. At this point, one of the senior advocates present in court, Dr. Onyechi Ikpeazu, requested permission to address the court, not as Kanu's lawyers, but as a friend of the court. The senior lawyer appealed to an adjournment, even if only until October 24, to allow Kanu to gather his thoughts and begin his defense. Justice Omotosho responded that it was for Kanu himself to make such an application, as he is now defending himself. I appeal to the defendant to make use of the opportunity given to him to enter his defense or waive it if he wishes, he said. In response, Kanu said he had not had enough time to prepare his defense, particularly given the capital nature of the trial, and that he also needed time to assemble the witnesses he has listed. Ultimately, Omotosho ordered that Kanu must open his defense without fail on October 24, 2025. And my people, on Afugo Keshiwere Onishioche, Mazi Nnamdi Kanu is now on the hot seat by himself, not by the help of any lawyer or any defense lawyer, but by himself at the court and also at the podium. Anyway, let's see what happens today. Today will be another day at the High Court of the Zoo, and I pray it will all end in praise. If you get this message, you know what to do. Like, share, comment, and make sure you keep subscribing for more interesting videos. I'll hear my voice again.